आपकी पूरी ठीक नहीं लग रही।
सर ठीक है, वो चल रहा है यहाँ पे, पोल्यूशन का है थोड़ा बहुत तो
चलो
आई
स्टार्ट
पे
करते
बात।
हैं।
जी जी।
Good evening, friends. Those who have been connected with Beyond Law CLC, they are aware that Dr. Charu Mathur, who herself is an advocate on record, coupled with the fact that she had also taken classes for how to crack the advocates on record paper, coupled with the fact as to what are the benefits and what is the role of AOR. These all sessions are on the Beyond Law CLC. Today, we thought that let's take a topic which is in sync with as we are celebrating 75 years of constitutional India. Article 15 and the reservation policy in India, constitutional mandate. Rather, while we speak on Article 15, there will be much emphasis on Article 15, subclause 3. She will also take us to the interplay of horizontal and vertical reservation, what would be that, coupled with the journeys in the reservation as such, with emphasis on Article 15. And thank you that despite the fact that Dr. Charu is not that fit, but mentally she's fit to educate us in all respects of Article 15. Over to you, and thank you for accepting our invite.
Thank you, sir. Thank you so much, and it is always a pleasure to be associate with Beyond CLC and with Vikas sir, in particular. And congratulations, sir, on your designation, much deserved. And we are always looking forward from your guidance for all of us. So, shall I start today's session? Yes, sir. So, good evening, everyone. So, today we are going to talk about Article 15. You all know that it provides for reservation and mandate in our constitution. Now, there are various aspects of Article 15 that we are going to understand. So, as you know, Article 14, it talks about right to equality in general, while Article 15, it is the, according to me, the foundational equality clause which has shaped the reservation policy in India. Now, if you look at the architecture of Article 15, how it has evolved right from inception. So we will look at I'll just give you briefly how I plan to take this session. So first, we will just go through the text of Article 15. We will quickly have a look at its historical evolution and amendments. What is the substantial equality doctrine? We will look reservation under 15.3, 15.4, 15.5 and 15.6. And in the last 3 years, if you look from 2022 to 2025, there has been a lot of change through the case laws that has come for reservation in particular. So we will be focusing on last 3 years. Now, let us just start with Article 15. So, I will be reading you the Article 15 subclause 1. So, as far as Article 15 subclause 1, it talks about prohibition on discrimination on 5 grounds. So, what are those 5 grounds on which Article 15 clause 1, it prohibits discrimination? So, it prohibits discrimination based on your religion, your race, your caste, your sex, and your place of birth. So, region, religion, race, caste, and sex are the 3 places on which it says that there cannot be any discrimination. Then if you look at subclause 2, it talks about denial of access to shops, public restaurant, wells, tanks, etc. So these are another things. They said that there is all the citizens of India, they have an equal right to access these places. Now you will think and ask why this thing was put in the constitution. So at the time when we became independent and subsequently when we became republic, it was a big issue that people of certain castes, they were not allowed to take water from certain wells. They were not allowed to access certain places, and they were not allowed to visit certain shops, certain restaurants. So the constitutional framers, in their wisdom, they thought that they need to put it way beyond, not just as an untouchability, but in Article 15, subclause 2 itself. Now, if you look at these 2 things, the 2 clauses that we have discussed up till now, that is 15.1 and 15.2, what is the tone of that? One of them is the negative prohibition that it has cast on the state, that state cannot do these things, that it cannot discriminate people based on region, religion, race, caste, and sex. And then it can say that you cannot prohibit people or you cannot discriminate people from accessing public spaces like your wells, tanks, restaurant, etc. Now, then came enabling clauses. So, first two were prohibitory, they were negative in connotation that you cannot do so. But 15.3, 15.4, 15.5, and 15.6 are more of enabling position. So, they are more of the positive direction which comes. So, 15.3 is makes special provision for women and children. Then 15.4, it makes special provision for socially and educationally backward classes of citizens, your SC, ST. And this came after Champakam decision. We will be looking at that also. Then your 15.5, let's talk about reservation in educational institution, including private, unaided institutions. So this still remains a big gap. This is one which is still open to challenges. And finally, you have 15.6, which provides for EWS reservation, which says that 10% EWS reservation is to be provided to the people who are not getting to the unreserved class, to put it simply. So, if you look at Article 15, Article 15 is both the shield against the discrimination and it is a sword of affirmative action. So, it plays dual roles. So, it shields you that you cannot do that, and it is a sword which it gives you the fight that this is a thing that you need to do. So, Article 15 essentially, when it says that you cannot discriminate, say, a person on basis of his or her sex, but at the 15.3, it provides certain kind of reservation to women and children. Likewise, when it says that you cannot discriminate on the basis of caste, then 15.4 says that, okay, if I need to provide affirmative action to the depressed classes, as they were originally called, then you have to provide it. Then it went on that not just only for jobs, but also for your education purposes. Then 15.5 is there. And finally, it says that it is not that only socially and educationally backward people are backward. People who are economically weaker, they are the ones, they are also suffering. So we need to elevate them from being the depressed class to the elevated class. So we will provide them a reservation. So this is what your Article 15 is basically about. Now, if you look at how Article 15 has grown over the period of 75 years, so first and foremost is the case of Champakam Durirajan. So in this case, it is a 1951 case. In this case, the Supreme Court had struck down communal reservation in Tamil Nadu. So they said that you cannot have reservation. Like in this, they said you can have X percentage of seat will be reserved for, say, Hindus, Y percentage will be reserved for Muslims, Z percentage will be remained for Christians, and so on and so forth. So they said that you cannot have communal reservation, and this matter, it reached in Supreme Court, and Supreme Court struck down this, and they said that you cannot have communal reservation. Now, the implication of this was that there was First Amendment to the Constitution, and because of that First Amendment to the Constitution, it said that Article 15.4 was introduced, which explicitly shows that reservation for socially and educationally backward classes can be provided. So they said that you cannot discriminate a person based on your religion, on your caste, on your race, but at the same time, with the First Amendment, they said that if we need to elevate the backward classes, say your scheduled caste and your scheduled tribes, then we can provide a reservation for them. So this is the first moment when reservation becomes a constitutional mandate and not merely a policy. So they said that, okay, our constitution says that we need to elevate the people, we need to bring out people from the depressed class status to come at par with the remaining citizens. So they said that, okay, generally we said that there will be equality, there will be no discrimination, but if there are people who are not on the equal platform, we should provide them with certain incentives with which they can come on this platform. Thereafter, the next, I'm not taking through all the cases. So the next part which came and which was very important was your Indra Swani's judgment. Now, as far as your Indra Swani's judgment is concerned, this is the one which is relating to your Mandal Commission. So, Mandal Commission, it said that you need to provide reservation to other backward classes, not just your SC and ST. Now, if you look at the history of Mandal Commission, so initially with the first Prime Minister, he said that you can have reservation but only at the stage of entry of the profession and not otherwise, right? Once you are in the league, then you need to take it forward, you need to take it forward, and you have to see that it is clearly provided for and people are able to elevate. You have given them a step to climb upon and then they can take it further. So he was against reservation in promotion. Then they had set out a commission also. The first commission was there, called Kaka Kelkar Commission was there. They studied various castes, subcastes in India, and they found that there are many other castes, but no heed was paid to it. Subsequently, you have Mandal Commission. It was during Indira Gandhi's time. It was the report had come, but she chose not to take reservation because the opinion was that it will fragment the society further. Right? You will have caste, subcaste, sub-subcaste, and the entire fragment, the society will be fragmented into the fabric will be stretched so much that instead of elevating it, it will become a very fragile society. But with the VP Singh government coming into place, they decided, rather he decided, that we need to provide reservation to other backward classes of the society. So with this Mandal Commission, they said that OBCs can have 27% of reservation. SC and ST were having 22.5%, 15 and 7.5%. So total it was coming to be 49.5% or almost 50% of the reservation. So at that time there were a lot of protests. There were people who have self-immolized that they had poured kerosene and students have burned because they realized that with reservation most of the people will not change. Now, this is one thing which has changed the entire landscape, entire fabric of the nation, that today you have litigation ranging for the reservation, not for your SC, ST or OBC, but for subcastes within in the OBC, right? Which are more backward classes or MBOC as we say. Those are the kind of reservation challenges that are coming. So today, because of the reservation, the idea which was there to provide reservation was to elevate people. Now it has come that I can prove I am so backward that I get the benefit of reservation. So Indra Swani's judgment, it was a 9-bench judgment, and it says that fine, you can have OBC reservation, and then it says, relying on the earlier decision, that 50% ceiling should be there, and then it talked about creamy layer. Now, if there is a backwardness plus inadequate representation is there, then you should get a representation. But suppose your previous generation has got, or you have become something in position in the society, then you should not claim reservation. If you are a creamy layered person, then that reservation should not be available. So creamy layer, as we understand, is when you take a milk and the thick layer of malai, as we call in Hindi, is there. That is the creamy layer. You take it out. You are already privileged, so I need not give you any reservation benefit, and hence it has to be taken out of the purview. So in this case, the court says that if there is a creamy layer, then you have to not give them the reservation. Now, what is creamy layer? How to determine it? And that again took lot of efforts to understand. Now, before I move forward, so this was general reservation. Then we come to two very important judgments. One is that of TMA Pai and second is of PA Namdar. Now, these two judgments, they led to Article 15, Subclause 5, and they provided for reservation of SC, ST, OBC under the private unaided educational institution, but they left minority education out of their fold. So that is still a debate going on, that how that we need to relook at these two judgments also. And then of course you have 130th amendment, which brought EWS reservation. This is by 3:2, which says that economic basis, or only on the basis of economic criteria, a reservation can be avoided. So in this, the minority opinion was of Justice UU Lalit. As a CJI, he gave the minority opinion in this decision. And he said that you cannot negatively, in this, the people who are getting 10% reservation are general category candidate. They are not the people who are already reserved. So he said that how can you, a person who is already depressed, right? He is educationally and socially backward, but how can you deny him the benefit of economic reservation? So he was in a minority, but the majority, they said that the reservation to the general category only on the basis of economic criteria can be allowed. So these are basically the clause. So if you look at what is happening, that there is a shift from formal equality to substantive equality. So generally when you say that treating like alike, right, in the substantive equality, you recognize systematic disadvantages. So in N.M. Thomas, in Indra Swani, then Ashok Kumar Thakur, they realized, and if I can give you the essence of these judgment, it is that equality is not the same thing as sameness, right? I cannot put two person at the same level if there is, you have to look at the background. Recently, Justice CJ, former CJ Gawai said that you cannot compare my son with the son of a tribal, though we both are OBC. He said, because of my position, my son has access to best of the best schools in Delhi. But a tribal who is also an OBC, he cannot provide the same benefits to his son. So on paper, on qualification, we are equal. I am OBC, you are OBC. But where I have reached today, by whatever means, whether by reservation or by merit or on both the criteria, today I form a creamy layer. So you cannot compare. So being equality is never the sameness. If two persons look alike are same, they are not equal. There will always be some fundamental difference. So that is a nuance that you need to look at. Then these judgments, they said that constitution permits different treatment to elevate equal outcomes. So they said that what is the idea behind reservation? Idea behind reservation is to elevate the depressed classes, and for that I am giving you the different treatment. My constitution allows it because there is a reasonable nexus to the object that I'm thinking to achieve. So, for example, for a general category candidate, I say that you require to have 60% of marks. But at the same time, I am giving OBC or SC, ST candidates, okay, fine, if you get 40 or 45%, I will let you enter the bar. So the bar is lowered so that people can come on equal plinth, right? But one very important aspect that you realize is the question paper. Suppose there is an exam, say a NEET examination is there for medical entrance. So it does not give two separate paper, one for general category and one for OBC, SC, ST. It tests you on the one single paper, but the bar is lowered. For a general category, I have to score 60% to get in. For a reserved category, I have to go into 40-45% or 45%, let us take. So the parameter on which you are tested are same, only the bar to enter the gate is lowered for you. So a student will not say that I have will prepare less because I have to secure less marks. The idea is you give your best. This is a philosophy which we need to understand. The idea is you give your best shot in the examination. As a state, I look that you are coming from a disadvantaged section. So instead of 60, I have lowered the bar for you to 45 so that you can go ahead in the race and reach the same level over a period of time with the 60% guy. Now, at this time, another important thing comes is if I am a reserved category candidate and if I score 70% marks, right? So will I get admission in the reserved category or will I get admission into the general category? So courts have consistently held that even if you are a reserved category candidate and you get marks only on the basis of your merit, then you will be coming into the seats which are reserved, which are for the general categories. You have not to go into the reserved category. So there has been lot of this thing that more and more SC/ST people are coming or OBC people are coming. They should come only in that category. That notion is wrong. If a person by dint of his or her merit comes in the merit list, despite whatever category he belongs, whether he is SC/ST, OBC or general, in the merit list he will be drawn there. And if he does not secure it, if not come into that merit list, and then he has to go into his category. So this is one very important point that we need to understand. Now, by providing these kinds of reservation, by providing these kinds of categorization, the Constitution, what it is doing, what our preamble says, that we have to secure justice, social, economical, and political, right? So by this is a transformative project of the government, of the nation, to elevate the depressed caste and bring them at par. So this is how the Constitution is transforming. I am not saying right to equality only means that you don't discriminate only on the basis of caste, sex, religion, region, or race. I say there are riders. I can give you reservation if you belong to these categories. If you are providing a woman or a child, if you are SC, ST, OBC, if you are economically backward, okay, I give you a reservation. So this is how you are transforming, you are molding the Constitution to reach the goal of bringing social justice to the people. Now, when we move to the next part, now as far as your women and children are concerned, there are scholarship schemes which are provided and various safety measures are provided within in the institution also. And thereafter, when we look into the various aspects about what kind of reservations you can provide. So I can talk about my home state, Rajasthan. So if there is a divorced woman or if there is a widowed woman, there is a certain post are reserved for those categories of women. Idea is to bring them at par. Even in the judiciary examination at the civil judge level, they were giving 10% reservation to women. So the idea was to make more and more women judges, and the effect of that we will be seeing in next 20-25 years. Now, when we talk about reservation, you will hear two terms, vertical reservation and horizontal reservation. So when we talk about vertical reservation, you put them the various categories, your SC, ST, OBC, and then you put horizontal. If there is a woman who is coming under this category of SC, ST, OBC, What will she get if there is a physically challenged person who is coming, if there is a transgender, or if there is a person with any sort of disabilities coming, where will, or a armed force personnel is there, where will they be getting reservation? So it is not that if I am giving 50% reservation, then for women I will be giving a separate. So women who are SC, ST, they can come into that category. So there will be something you will be hearing called interlocking, where your horizontal and vertical, they will just interlock. So if say I am asking for a women reservation, right? And women is say ST. So women is getting horizontal reservation in the category of ST, where they two meet. That is grid is locked, and she is getting ST women reservation in that category, right? So you need not provide reservation to another ST women if say there is only one post. Now, there are some more judgments which are coming these days. There are two or three which I wish to discuss with you. One is your the Constitution Bench judgment in state of Punjab versus Devinder Singh. Now, in this case, the subclassification of SC/ST was upheld. So, in this case, the Supreme Court said that subclassification among SC/ST for more equitable distribution of benefits is permissible. Court also said that creamy layer proposition will apply to to the SC/ST also, and not just to the OBC category. And how do you evaluate? You do it on the basis of empirical evidence that you can provide. Now, the court said that the idea behind this is to strengthen intra-group substantive equality. So, within in a group, if suppose a person is SC/ST and he comes into the creamy layer concept, then you remove that SC by giving him the benefit of creamy layer. So, he does not compete within in his category. And the others who are not so fortunate, right, they will be getting benefit. So if you look again, I will talk about my home state Rajasthan. So we have lot of minas are getting lot of reservation, that at one point of a time the maximum number of IAS officers, IPS officers were mina. Now the issue is that their second or third generation cannot claim benefit because they are already a privileged class. So this is an important judgment. This is only relating to Punjab, was state of Punjab versus Devinder Singh. This constitutional bench judgment, it said that you can allow the subclassification. Now, there have been something known as reservation into the various categories of which category you provide. So, there is a central OBC list and there is a state OBC list. So, if you migrate from one state to another, what happens? Suppose I am a backward class citizen or a OBC candidate in, say, state of A, but I am not so in state of B in the state list, but there is a central list where I come. So where will I get the benefit? So in this case, the court went on to say that reserved category candidates using relaxation cannot claim general seats, right? If you are claiming that I am a reserved category, then only on the basis of migration, you cannot say that give me those seats. So suppose there are central universities, right, where they are providing reservation to various categories of person, then in that case you cannot say that you give me the reservation. So if I am a person who is if I am a person who is saying that give me reservation, then I migrate from say state of Rajasthan to state of Punjab, then you cannot claim reservation. If you are claiming under the state quota, you have to do under that particular quota only. So one case that I fought in Delhi High Court was regarding whether the central OBC list will be applicable or state OBC list will be applicable. So then we went on to look into the issue. Eventually, we won that matter. We were for interveners in that matter, and we said that because it is a state funded university, right? They are getting the central aid, so only the central OBC list will be applicable and not the state list. So, this is, you have to look from where you are getting funded and where its affiliation is. And I think it will require some strong decision from Supreme Court, maybe some constitution bench decision at some point of a time, which will authoritatively decide upon when the central OBC and when the state OBC will apply. What will happen if the state OBC, a person migrates from one state in which uh, he is OBC, but not in the other state. Then there is another case in which of Vikas Gwali, where they dealt with the local body reservation cases. So in this case, the court, they said that there is a triple test that you need to pass. First, there has to be a dedicated commission who has to find out what is the whether the person, the SC, ST or OBC or other backward classes, they are actually in are actually backward or not. So there has to be an empirical study need to be done. There has to be a quantifiable data for the same, and 50% ceiling is to be provided. Now, despite the decisions of the Supreme Court, states like Maharashtra, MP, and Karnataka, and particularly Maharashtra, it is coming to Supreme Court on this issue again and again as to what can be the ceiling for one pretext or other. And eventually, this is one thing which needs to be settled down, that in local bodies election, how do you fix what is the maximum amount of reservation that can be provided? Then, of course, we have the decision of Jarnal Singh, which is on the promotion of SC, ST. And this decision says that if you apply the creamy layer, it applied. If state shows the dominance of the advanced group, then they say you apply creamy layer provision. Then data for backwardness and inadequate representation, it must be contemporaneous. So whatever is the contemporary data that is there, that exercise is to be done and that data is to be provided. Now, when we talk about the reservation in general, right? When we talk about reservation in general, you will see that there is growing clamor for more and more reservation. You have decisions like Nalsa. Recently, there is a decision by called Jane Kaushik, where you are asking reservation for transgender persons or for physically challenged person. And this is a clamor which is going on. That idea behind reservation remains, whether it is essentially now fight is for the horizontal reservation, right? So the idea is that you need to provide them with the reservation, and how do you provide it? So recently for the transgenders in the Jane Kaushik case, the court says that they are the one who are depressed, and within in the interlocking, if they come, right, if they belong to that class, then you have to provide certain reservation. So I hear some query coming from Mr. Miran. He says that defense and judiciary, no reservation. What might may be the reasoning or concept? See, as far as reservation is concerned, so you do have reservation in judiciary also, right? When you enter your various examination, there is a reservation in judiciary. In military and all, in the armed services, it is not that there is no reservation. If you are going through any competitive examination that is there, the rules provide that you need to provide the reservation. So the reservation is very much there. So now I open the floor. If you have any question, then I'll take it further.
I'll just check it on the YouTube. Now, if you have seen that they say that you have to have a quantifiable data, number one. And number two is they also say that you will also have to show that whether within those particular segment, let's assume class A, class B, class C, and class D, whether there has been an adequate representation, etc. So, are there any instructions or what is the development of law after the judgment of Jarnail Singh? Hello?
Hello. Yes, sir.
I was asking, since the question was after the judgment of Jarnail Singh, where it said you have to have the data, etc. Now, what is the position now where there is no data collected for the purposes of promotion or seniority?
So, sir, they have to collect data like BK Pavitra was also there, 1 and 2. They said that you need to have a quantifiable data. One thing that they have done away is when you say that efficiency should be there, right? So they said that if you are coming through reservation, it does not mean that person is not efficient, which generally the reservation class people were targeted with. So the data, it has to be provided, empirical data is to be provided.
So, in the absence of the same, what will be the position of law?
So then reservation will be there. It is, if it is only, it has to go beyond. Like for SC/ST, you have to give 22.5, and for OBCs, you have to give 27%. The issue was coming in the states of Tamil Nadu, where states like Tamil Nadu, where the reservation was going to 90% and 100% also in some cases. So they said that whatever data is available, the government has to endeavor that that data is provided. If it is not, then whatever the existing data is there, they will go on that.
In what ways do you feel that Articles 15 and 16 can work together?
See, Article 15 and 16, I mean, they both are facet of Article 14. They provide Article 15 is more in a general way about the reservation that you don't discriminate on the basis of caste, sex, religion, region, and race. And then it provides various nuances for the same. Article 16 is more towards your public employment. So that is the basic difference that you can take.
So, thank you, ma'am, for sharing your knowledge on wide spectrum of law, and that too, culling it out in a around 50 minutes capsule is quite amazing, and I'm quite sure that people would appreciate it. So, everyone, stay safe, stay blessed. Namaskar.
Thank you, sir. Thank you.